Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Hello and welcome back to the Estate Blueprint with attorney Thomas D. Begley III, founder of Thomas D. Begley III LLC in Moorestown, New Jersey. Tom is a certified elder law attorney with more than 35 years of experience helping South Jersey families protect what they've worked for through estate planning, special needs trusts, medical planning, and probate administration. My name is Kevin Rosenquist. I am your host today, and we are going to talk today about the mistakes that people make and how you can fix a broken estate plan. Tom, welcome back.
Good to be back.
So when you say broken estate plan, what do you mean by that?
Well, basically, Kevin, estate planning is a very important part of individuals' lives. When you look at it, if you ask most people what their goals are as far as their assets are concerned, they want to make sure that they can enjoy them while they're alive, but they really want to make sure that when they pass away, it goes to their loved ones and in the manner that they want it to go. And unfortunately, many people don't appreciate or get proper advice when they're setting up their wills or their trusts and overall their plans. And when they pass away, what they wanted to see happen with their assets doesn't happen. That's really what a broken plan is. So.
And what generally causes an estate plan to be broken?
Well, I find that estate planning gets broken for one of three reasons. One is no planning. The second is poor planning. And the third is incomplete planning. So I'll give you an example of each. For no planning, that's obviously what it is. I had a case that I'm working on where an individual told his nephew that he was going to give him the entirety of his estate when he passed away. However, even though he was in his mid-70s, he never got around to executing a will. And because he never got around to executing a will, his probate assets are going to pass to a number of people. Basically, due to the intestate laws, there were 5 brothers and sisters, and she actually wasn't any of the children at all. So she technically doesn't receive anything, and it's going to go to everybody else. So fortunately, he has a really nice mother who's going to disclaim her interest and make sure that by doing a disclaimer that it'll be split equally between him and his sister. But that's not exactly the way we want it to go. So, there are some things we're trying to do to fix it, but unfortunately, it's caused a bit of an expensive mess. That's no planning. The big plan time, no planning actually hurts is when somebody's alive and they get sick and they have to go to Happy Acres nursing home, and it costs $1 zillion a month. And we're trying to minimize long-term care costs, but because the person doesn't have a power of attorney, we have to go to court and get a guardianship to try to fix it. Now, the big one that we get is poor planning, and that's where someone either goes to John Doe attorney at law whose qualifications to handle estate planning unfortunately don't exceed his mere desire to cash a check, because he does a little bit of everything. And what's that old saying, jack of all trades, master of none. Mm-hmm. And I do see a common recurring theme of mistakes that happen. For example, many individuals have children who have disabilities, and those children who have profound disabilities or severe disabilities survive on 2 needs-based government benefits. One is SSI, which is where they get a monthly income stream, and the second is when they get Medicaid, which is their health insurance. And in order to maintain those programs, they can't have more than a couple $1,000s in their name. So they go to John Doe attorney at law, who says to himself, well, we just have to put everything into trust because John has Down syndrome and certainly he's not able to handle his money, so we'll have somebody handle it for him. And they think that's all that person needs to do. But they'll say the person can just disperse the money for health, education, maintenance, support, which is called the HEM standards, the first initial of each of those assets, each of those attributes. And as a result, that disqualifies the individual for those benefits because that's the standard that you cannot use when you're trying to take care of an individual with disability. You can leave assets behind to an individual with disability, but it has to be what's known as a special needs trust, which actually specifically states that the trust is to supplement rather than replace needs-based benefits, and it has to certainly can't use that criteria that's used in the support trust. So that's basically, so somebody basically screwed it up. The third, and this is probably the biggest, is that people don't recognize that a will oftentimes doesn't even cover most of an individual's assets. And let me be clear. When you have a married couple, oftentimes it doesn't matter because when one person dies, it goes to the surviving spouse and vice versa. But when somebody's single and they pass away and they want to leave assets behind to their children or other relatives, they think when they go to John Doe Trent Law or when they pop into the internet and try to draft a will that way, that everything is going to pass through the estate, through the probate process. However, the will only cover assets that are owned by an individual, such as a bank account or a brokerage account or a piece of real estate that does not have either a joint owner or a beneficiary. There are three big exceptions that pass outside of probate. The first is IRAs, retirement plans, annuities, and insurance. So if you have a will that has a certain set of beneficiaries, but the IRAs and the insurance have another set of beneficiaries, your goals aren't going to be accomplished.
Right.
The other thing that we have is people that have assets that are joint with the right of survivorship. Some people, as they get older, they have their children put on as joint owners on an account, and they forget or are not aware that when that person passes away, the deceased, that everything is going to go to that child who typically I found will do the right thing and share with his brothers and sisters, but not always.
Yeah.
So those are things like that. So what I wind up doing is making sure that when people come to meet with me that I direct those assets to go in through the will and in through the trust that the way that they want to accomplish their objectives. I find that happens in two big scenarios. One is when we're dealing once again with an individual who has special needs. So we don't want to have, in that particular case, John who has, Down syndrome, we do not want to have him get a support trust. We want to have a special needs trust under the will or the trust. We also want to make sure that if there's any non-probate assets, such as an IRA or insurance, that the beneficiary is not him, but it's his trust. So I've seen people set up great trust to take care of their child, but then they blow it all by not taking care of the other assets by pointing them in the right direction. The other one actually is we're doing more and more. This will probably be a nice topic for a future show. It's what's called a bloodline trust, where we're leaving assets behind for children to make sure that it's preserved for them during their lifetime, but is exempt from issues such as creditors and divorcing spouses, etc. But once again, the way for that to work is that the assets have to pass into that trust upon death. So I've had people set up these great trusts, but when they pass away, they have a $900,000 retirement plan, and $450,000 goes out right to the child who's in the middle of an awful marriage, and which kind of thwarts the planning. So that's the incomplete planning.
Okay, so we established that I have a broken plan, all right, and I come to you. What can I do to fix it?
So there are two things that you can do, and also right from the get-go, I got to be completely clear. There's no guarantee that you can fix it.
Right.
But in New Jersey, there are a couple ways that you can try to fix it. Now, in the case where I have the individual who's supposed to receive, from another relative, and unfortunately that estate's going to be divided by intestacy among a bunch of people, there's a thing called an agreement to forego litigation. So if the beneficiaries agree, along with the administrator of the estate, as to how the asset should be divvied up, that's enforceable. Now, I think in this particular case, it'll solve some but not all of the problem, because I don't think we're going to be able to get 8 people on board in this particular case to decide what's going to happen to reflect the deceased person's wishes. But we can make a awful situation probably a bit better. Mm-hmm. The big thing you do, and this I do frequently, and this is really to correct the incomplete or the poor planning, is what's called reformation. So once again, using the disabilities example, I have the case where mom is a widow and she has a will that's going to leave everything 3 ways, and she wants to leave a third to her son, John, who has the disabilities. And she has first a support trust, and then secondly, she has a life insurance policy that leaves $500,000, or let's say 50%. Let's make it, we'll make it a $900,000 policy. So she's 300,000 is going to go to John outright. So both those things would blow up John's benefits. So what I've done is gone to court and asked, under what's called the doctrine of probable intent, for the court to change the language of the will or reform it so that rather than John's share to go into a support trust, it goes into a special needs trust. And the theory behind that, and the courts have been pretty understanding, is that if the person had known about a special needs trust and knowing that it was imperative for their child to maintain their eligibility for needs-based benefits, they would have done the right steps to make sure that those benefits were preserved. So basically, we're not, going to penalize somebody for an attorney that did not do the right thing, or B, a software company that put a product that was less than optimal. And then the other part, I've had this case change the beneficiary of the insurance or the annuity of the IRA, so the portion that was supposed to go to John is going to go to John's special needs trust instead. And this is stuff that it's been relatively new. I mean, when you talk about the history, up until 20 years ago, you couldn't do anything except change a will around, unless you were really, really lucky and the probate judge, kind of bent the rules, because up until 2005, really, the court oversaw wills and trusts, but that was pretty much about it. In 2005, they started looking at anything that somebody else could own. They refer to it as now the governing instrument, and that would include, deeds, life insurance policies, annuities, etc. So, but nowadays, you go to the court and say, look, this was the intent. Now you have to notify, everybody that's a beneficiary of the will and the family, etc. It is possible that it couldn't get contested, and if that's the case, there's no guarantee that's going to go through. Fortunately, in that particular area, I haven't seen anybody be, that wicked to mess up like a child with disabilities, benefits. Mm-hmm. So there are things that you can do to fix things.
Yeah. Well, so how best can someone avoid these mistakes from the get-go? How can they make sure that they have an appropriate plan out the gate?
Well, that's probably, almost a rhetorical question, Kevin, but it's the right one to ask as we wrap up this episode, and that is make sure that your affairs are in order to begin with. Look, nobody wants to pay money to get this sort of work done. First, nobody wants to pay money to a lawyer to begin with. If you and I had a choice, even me as a lawyer, if I had a chance to go see the Eagles this weekend, or, the Sixers next weekend, or go have a really nice dinner with you or some other friends, or pay money to a lawyer, I'd rather do anything but pay the lawyer.
Right.
And the second is just who wants to talk about topics such as death, feeding tubes, mental incapacity, and people fighting over your money when you're dead. But you just have to kind of suck it up and make sure that you handle it the correct way. And the correct way is go to somebody that is a professional who focuses solely in this area of practice, and sit down with them and make sure that they evaluate what you want and reduce that to writing in the form of will and or trust. And secondly, that they observe and account for all of your assets to make sure that they pass through the will and the trust to be consistent with what your objectives are as far as estate planning. So you don't have to call somebody after the fact. Years ago, somebody asked me what I thought about the software. And I'll say some of the software has gotten much better over the years. Don't get me wrong.
Yeah.
And I said, I think it's great. And they're like, what do you think it's great? Is there that competition? I said, no. The person who wants to entrust their, estate to software, they're not paying me money to get the job done correctly to begin with.
That's true.
And secondly, and I say it sarcastically, but it's true, is that I make a lot more money fixing mistakes than doing it correctly to begin with. But frankly, I would rather see families keep their money and not have to pay more to correct the penny wise and pound foolish attitude.
Yeah, we all, because of the internet, because of cell phones, because of AI, we're a DIY culture in a lot of ways. talk to friends who do more stuff around their house because they have YouTube. They can look at videos and be like, hey, I think I can do this. Doesn't always work, but more so than they might be able to without it. But you're still, in every situation, when a professional would do a better job, you are risking something, whether it's you're doing your taxes, like I said, doing that home project, or doing an estate plan on your own.
It's correct. Yeah, it's almost like those old commercials from about 20, 25 years ago where that Holiday Inn ran, where some guy was on an operating table and the person that came in was dressed up as a doctor but wasn't, and the response was, well, I'm not a doctor, but I did spend last night at a Holiday Inn Express.
I remember that. Yeah.
Funny for a commercial, but not for trying to administer somebody's estate when it goes awry.
No, I would agree with that. All right, well, that's it for today's episode of the Estate Blueprint with attorney Thomas D. Begley III. To learn more about Tom's work in estate planning, trust administration, and elder law, visit Begley3law.com. That's the number 3. You'll find resources to help you protect your assets, care for loved ones, and plan with confidence. Thanks for listening. Don't forget to subscribe, share, and leave a review so more South Jersey families can find the guidance that they very much need much of the time. Tom, really great seeing you again. Thanks so much.
Take care, Kevin. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.